A couple days ago, Sarah Boone filed a motion for a new trial and laid out a number of reasons why she deserves a new trial. One of the reasons is that really she never forfeited her right to counsel. As we all know, we have a Sixth Amendment right for effective assistance of counsel, and Sarah Boone said that she never waived it. I know that it was difficult for her to get an attorney to work with, and people were withdrawing, but she never waived that right. So if she doesn't voluntarily, knowingly, and intentionally waive that right, well, then maybe she deserves a new trial because she was supposed to be representing herself. The court didn't appoint her a new attorney. And then finally, when she got James Owens to represent her, it was too close to trial. He didn't have enough time to prepare. And because of that amount of time that she was representing herself, therefore that rendered James Owens ineffective. So essentially the question here is that for that time, that period of time when she did not have counsel representing her, is that a constitutional violation? So that was one of the reasons, one of the basis for this motion for a new trial. And I told you, we went through the motion, we read through it together, and I told you at the time that I hope to go do some more research on that. Of course, there were some other matters that I had to attend to as well during that time, but I told you I was going to go do some research and come back and report back to you about what I found in terms of the case law with that specific issue. And there's some other issues that we can also look into. But today, I really just want to focus on that specific issue because I think it's a very interesting issue about when a person has the right to counsel, when you can knowingly and voluntarily waive that right to counsel. And then also the question is going to be, is there a possibility to forfeit your right to counsel? And is there any difference between the two, waiver versus forfeiture? So that is what we're going to be going into today. So before we do, I do want to give a shout out to our sponsor of this video, The Suit Depot. The link is in the description. A great store that sells very high quality products and apparel, suits, apparel, and for very, very reasonable prices. And especially now, you get a 10% off discount because you are a listener of Brother Counsel. You're a subscriber, a viewer. So when you are shopping at the Suit Depot, you just hit that link in the description. It'll take you straight to Suit Depot. When you're checking out, just put in Brother Counsel, no spaces, all lowercase in the coupon box, and you will get 10% off. All right, so let's jump into this specific issue, and we'll see if there's any sort of merit to it. So I'm going to pull up the motion. I'm going to be jumping around to some different case law, as we like to do on this channel. We'll talk about the cases that James Owens cited. We'll talk about the cases that the judge cited in his order way back when he found that Sarah Boone is going to have to represent herself. We'll talk about that, and we'll see if there's any sort of argument here that perhaps Sarah Boone is entitled to a new trial. So let's add this and let's start. So this is argument one. So argument one, that's usually you start off with your strongest argument. So let's go through it again together. We'll read through it, and then we'll talk about the case law. The trial court erred in holding the defendant was not entitled to court-appointed counsel. In the above-styled and numbered case, the defendant had approximately 7 court-appointed attorneys prior to the undersigned counsel taking her case. Undersigned counsel took on the above case because he was concerned that Ms. Boone would not have an attorney to represent her at trial. The above case was very complex, even for a seasoned trial attorney who was the public defender of the First Judicial Circuit for years, as well as having a thriving private practice. It was apparent to undersigned trial counsel that Ms. Boone would be grossly ill-prepared and unequipped to handle a trial in this manner, or in fact, to handle any other phase of the trial without counsel. Both the Sixth Amendments as well as Rule 3.111 Florida Rules of Criminal Procedure guaranteed an indigent defendant the right to appointed counsel. Okay, so that is not of dispute that the Sixth Amendment and the Rule of Criminal Procedure, Florida Rules of Criminal Procedure guarantee that even an indigent defendant gets the right to appointed counsel. So that case law is assuming it's going to be fine. And if it's not this case, it's another case because it's pretty well cemented. So Bowden versus State versus Kelly, and progeny. There appear to be 2 exceptions to this precedence. Number 1, if the defendant physically harms or threatens to harm his or her counsel. And 2, if the trial court certifies that the defendant will not be incarcerated if found guilty, i.e. a judge trial. Should the court determine that the defendant is not entitled to court-appointed counsel due to misbehavior on the part of the defendant, the court must follow a process which protects the individual's right to due process as well as the defendant's right to the assistance of counsel. So they are making, James Owens is making an assertion here. This is the assertion that the only 2 exceptions are if the defendant physically harms their counsel or threatens to harm counsel, and 2, if the trial court certifies that the defendant will not be incarcerated if found guilty, meaning it's a judge trial. In the instant case, undersigned trial counsel would assert that Ms. Boone's behavior did not rise to the level of misconduct to warrant a waiver of the right to court-appointed counsel. Now, remember, there's a difference between waiver and forfeiture. And here they're calling it a waiver. Now, Ms. Boone never waived her right to counsel. She never waived it. I wouldn't be calling this a waiver. I'd be calling this a forfeiture against her will. Okay, that's just a little semantics problem there. And if the court determines that she waived her right to court-appointed counsel, then the court failed to warn her or inform her that continued misbehavior would result in a waiver of the right to court-appointed counsel. Under controlling precedents, failure of the court to appoint trial counsel can result in a motion for a new trial being granted. And they cite 2 cases here. So the only 2 cases from this entire section of their argument are these 2 cases, Figueroa Sanabria versus State and Wilson versus State. And then they say progeny, which, okay, your guess is as good as mine. Progeny just means all the cases that follow. But I mean, what do you suppose, all the cases that go in line with that. But I mean, seriously, you got to actually cite the cases. So the only cases that we have here is these 2 cases. And the only other cases that they cite, which stand for anything, is just to say that an indigent defendant is guaranteed the right to appointed counsel under the 6th Amendment and Rule 3.111 in the Florida Rules of Criminal Procedure. So, okay, fine. So that no one's going to dispute that. But the ultimate question here is, at what point does a person forfeit their right to counsel? That is the question. So if you want to cite a case, you're going to have to cite some cases that show conduct where a person or where a defendant engages in that conduct and the judge found in that case that they waived the right to counsel, or what conduct is not sufficient to rise to a level where it's considered that you forfeited your right to counsel. That is what you have to do. If you want this motion to have any sort of teeth, that's what you have to do. Go find those cases. So the only cases we can really look to are these 2 cases. Now, what do these 2 cases talk about? Okay, so let's pull up these cases. We have Figueroa Sanabria versus State and Wilson versus State. So let's take a moment break from this brief and let's pull up those cases because I pulled them. That's what you got to do if you actually really want to know what's going on. So let's talk about this case first. Figueroa Sanabria versus State. Now, what happened here is that this individual had trouble with this defendant, Figueroa Sanabria, had trouble with his counsel. He really had a lot of trouble. He was constantly asking the court to give him new counsel. He wanted a different counsel besides the counsel that was appointed to him. He was an indigent defendant, and he wanted a different counsel. Now, throughout the trial portion of this, the court did not grant his request. So this defendant wanted a new counsel. He was represented. He was definitely represented the entire time, but he didn't like his representation. He wanted a different attorney. Now, as we've spoken about in previous videos, your right to appointed counsel is just your right to appointed counsel. You don't get to choose your appointed counsel. That's not what's guaranteed under the 6th Amendment. If you're appointed counsel, as long as that counsel is effective, so then your constitutional rights are being protected. So even though he was asking for it, the judge never granted it. And in fact, on appeal to the Florida Supreme Court, the Florida Supreme Court found that was fine. The attorney did a fine job, even though you don't like him and you thought he wasn't doing a good job, but he did a fine job and it wasn't considered ineffective assistance of counsel. I'm sorry. But what happened in this case was a little interesting. It's actually a very interesting case. If you want to read the entire case, you see the site right here. It's an interesting case. But what happened is that then they went to the sentencing phase, right? So he was found guilty, and then they went to the sentencing phase, and he was actually sentenced to death. Now, during the sentencing phase, normally, if you're the attorney representing the defendant, what you want to do is you want to present mitigation evidence. You want to present evidence which would be considered mitigated, and there's factors that are aggravated and there's mitigated. So if you have a lot of aggravated factors, then it's much easier for the jury to find that you should be deserving of the death penalty. If you present mitigation evidence, so then the jury can take that in consideration and maybe not sentence your client to death. So that's an important part of representing a defendant. You want to present, during the sentencing phase, you want to present mitigation evidence. Now, what happened in this case is that the defendant, for whatever reason, this guy, Sanabria, didn't want his counsel to present any sort of mitigation evidence. So he didn't want him to call his family members and say, oh, what a wonderful guy he is, and how much community service he does. He didn't want any of that to go on. Now, the defense attorney felt, I have to do that. That is what I'm here for. That's why you have counsel for the sentencing phase. Now, it is during the sentencing phase, it is a time when you still have a right to appointed counsel. It's not just for the guilty or not guilty verdict or trial that you get it, that you have this constitutional right to appointed counsel. It's even during the sentencing phase, all critical stages of the case. And what this defense attorney felt, that I need to present mitigation evidence. And what the judge did is the judge told this guy, this defendant, that, look, if you want this counsel, then he's going to present mitigation evidence. If you want to represent yourself, you can do that and then choose not to put on mitigation evidence. So that was what the choice that he was given, this guy Sanabria. You can either choose to be represented during the sentencing phase, and then that means that you have to agree with your counsel to present mitigation evidence, or you want to do this yourself and not present it, no problem, you can do that yourself. That was the choice that he gave him. And because he was under this impression that he had to choose either a counsel who's going to present mitigation evidence or represent himself and then not present mitigation evidence, he chose to represent himself during the sentencing phase, and then he was sentenced to death, as you can imagine, because he didn't present any mitigation evidence. Well, here is where the Supreme Court found that this case has to be remanded. It has to be reversed, at least the sentencing phase. The guilt phase is fine. He was found guilty, and he had good counsel. He had effective assistance of counsel. Everything was great there. It was just when it came to the sentencing phase that, because they gave him these two options, and these two options really is not true. These aren't the only two options that you have. You can be represented by an attorney and tell the attorney, I don't want you to present mitigation evidence. You are allowed to do that if you're a defendant. And that is exactly what the Supreme Court in Florida, in this case, found. This is a pretty recent case. This is a 2023 case. And this is what the Supreme Court said. Even if defendants exercise this right to appointed counsel, all competent defendants have a right to control their own destinies. So it's not like you have a counsel and then you're just completely giving up all decision-making to your defense attorney. No. Our system of laws generally presume that the criminal defendant, after being fully informed, knows his own best interests and does not need them dictated by the state. This means that by exercising his constitutional right to the assistance of counsel, a defendant does not relinquish his right to set the parameters of that representation. In line with this principle, our case law affords competent capital defendants great control over the objectives and content of their mitigation. Therefore, regardless of whether the defendant is represented by counsel or is proceeding pro se, the defendant has the right to choose what evidence, if any, the defense will present during the penalty phase. Here, however, the trial court informed Figueroa Sanabria that if Hernandez, meaning his attorney, represents him, he's going to present mitigation on his behalf, effectively telling Figueroa Sanabria that his right to the assistance of counsel was conditioned on the presentation of mitigation. Faced with this choice, one he should not have been forced to make, Figueroa Sanabria decided to proceed pro se. So, therefore, this is a case where the Supreme Court said, because you gave him this choice, which is really not true. He could have been represented by counsel and then told the counsel not to present mitigation evidence, and the counsel would have had to listen to him, and he wasn't given that option. So therefore, this waiver was not knowingly, intelligently, and voluntarily entered into. And that's why the court reversed. Now, what in the world does this guy? I mean, it's a very interesting case. But what in the world does this have to do with what happened in Sarah Boone? Does it have any connection at all? No. All this is saying is that during the sentencing phase of a case, if the judge forces you to waive or forces you to go into these two choices, and one of the choices are wrong, and you don't have counsel for the sentencing phase, so then you get a redo. That's reversible. But what that has to do with the Sarah Boone situation is your guess is as good as mine. So this case really does not have anything to do with her going through so many attorneys and then the judge saying, okay, you've gone through so many attorneys. Now I'm going to say that you have to represent yourself. There's no sort of similarity to what happened in this case to what happened in Sarah Boone's case. So again, this case is completely nothing to do with, it's not going to help Sarah Boone's motion for a new trial. All right, well, that's just one of the cases. They cited another case as well. So let's see that other case that they cited. Maybe that case has something to do with it. So this was the case of Wilson versus State. Okay, Wilson versus State. This is a case where, well, it's pretty short, so let's go through it. The trial in this case began on Tuesday, August 18th. Jury selection began at 2 p.m. The jury was sworn in the same day, 4:48. So it was Tuesday, August 18th. The case was over. Jury began deliberations on Thursday, August 20th. So 2 days later, the case is over. The jury has the case. Now listen to what happened. At the end of the day on Thursday, the trial judge discussed a scheduling issue with the attorneys. Defense counsel, Marshall Geiser, had business to attend to the next day in Washington, D.C. So this is the end of the day of Thursday, 2:22 p.m. Jury deliberations began, and the defense attorney has to leave town. He's got to go to Washington, D.C. So he can't sit with his client while the jury is deliberating. Now, what's the problem with that? Well, the only problem is let's say the jury has a question. That's the question. So the trial court was trying to figure out what to do about, are we able to call you? And this was in the year 2000. And apparently this defense attorney, he did not have service, or his phone contract did not allow him to get phone calls in Washington, D.C. It was only limited to Florida. So they had trouble getting a hold of, they would have trouble getting a hold of him if the jury had a question. So what they decided to do was he was going to go on his business trip. They're going to allow the jury to deliberate. And if the jury comes back with a verdict, okay, then great. He can have some other attorney sit in with the defendant, and then they'll accept the verdict together. And there's nothing really for the attorney to do at that point. So, and if there's a question, so then, they'll have to wait till Monday to discuss it. So this is what happened. What happened is that actually on Friday, the jury came back and to deliberate. On Friday morning, this is what happened. Listen to this. On Friday morning, the jury returned to deliberate at 8:17. That morning, the jury sent out a note asking, how long must we stay in here if we cannot reach an agreement? So it seems that the jury was locked. During the court proceedings, in response to the note, the stand-in attorney took the position that appellant was not his client and that he cannot give him legal advice. So here we go. You have a question. I'm just standing in for this guy's real attorney. I'm not going to take a position on this. This is not my client. I should not be able to give him legal advice. The trial judge discussed reading the deadlock instruction. So he was discussing, okay, maybe we should read the Allen instruction. What should we do? They were discussing it. And then listen what happened. While the court was mulling over what course of action to take, the jury reached a verdict. The verdict was published at 10:20 a.m. and that was it. The judge had the clerk pull the members of the jury. Everything was great. So here the question is, was there any sort of reversible error because there was no, his real attorney, the defendant's real attorney wasn't there when this note came out and was read and they were discussing what to do. So does that mean that he did not have counsel with him at a critical stage of the trial? And here the courts held that no. We agree with the appellant that the stand-in lawyer did not function as the counsel contemplated by the constitutional guarantee. Although he's a warm body, okay, so he was not considered counsel. So just by this stand-in attorney being there is not considered counsel, but because nothing really happened, there was nothing really to be done in this case, nothing to be argued, and while they were still talking about it, even if his attorney would have been there, the jury came out with a verdict. So there's nothing would have changed. So that's what ended up happening in this case. Now, the Just want to see here. Okay, so that's what happened in this case. So again, nothing here really says anything that has to do with the Sarah Boone case. It was just they talk about the absence of defense counsel during critical stages, which would include receiving the verdict. Okay, they talk about that in this opinion, but what that has to do with Sarah Boone's case, again, is your guess as good as mine. This has really nothing to do with going through 7 different attorneys. And now is the court allowed to tell you, the defendant, that you're not allowed to have an attorney now, and you've effectively waived your right to an attorney? This case has nothing to do with that question. So again, like we said, if you are the defense, you've got to find a case that talks about your scenario. When is a judge allowed to tell someone that you're not allowed, that you've effectively waived your assistance of counsel? And both of those cases don't stand for that proposition at all. So we went through the cases that were cited by James Owens, and none of them have to do with this specific argument. You got to find a case that talks about the facts in your case, or at least somewhat similar, not just generally speaking, when does a person have the right to counsel during the sentencing phase and during receiving a verdict and whatever that other case talks about, but when has a defendant effectively waived that right? That's the question. And those cases have nothing to do with that. So now let's actually talk about the cases that the judge found in his order. The judge cited these cases in his order when he, a couple months ago, told Sarah Boone, this is your last chance. You don't, if you mess it up with this last attorney, you're going to have to do this alone. You're going to have to do this pro se. And he cited some cases. So which cases did he cite? Well, let's talk about it. Let's pull it up. So first, let me just show you part of his order. This is part of his order. It's a 16-page order. We're not going to read the entire order, but I wanted to just read the part where he talks about forfeiture. Forfeiture of right to counsel. A defendant in a criminal case can forfeit a right to court-appointed counsel. So that's the first question here. Can a defendant forfeit his right? Meaning you have a certain right, you could either waive it, but is it possible for you to forfeit that right? Can you do something that would require the judge to say, you know what, you forfeited your right to appoint a court-appointed counsel? And it says, yeah, this is what the judge says. Now, does he cite a case about that? Well, he certainly does. A forfeiture is an extreme measure that flows from the defendant's abuse or manipulation of the right to counsel and results in the defendant being required to represent himself even though he has not waived counsel and may still want legal representation. So they cite a case here, KR versus Department of Children and Families. Well, let's take a look at that case. Let's be fair. After all, we got to be fair, right? So let's pull up that case. And let's see what this case has to say. Under the United States Constitution, criminal defendants have a right to counsel and representation. In a typical criminal waiver, remember there's a difference between waiver and forfeiture. In a typical criminal waiver of court-appointed counsel case, the focus of the court is whether the waiver is knowingly, intelligently, and voluntarily made. So when it comes to waiver, it has to be that you actually know what you're doing because you are knowingly waiving this right that you have. The trial court is obligated to conduct a Forfeiture hearing and to otherwise warn a litigant of the dangers of proceeding pro se. So basically, the court is to make sure you understand what you're doing. That's what this hearing is for, Forfeiture hearing. You have to make sure that everybody understands what's going on here, that the defendant understands that he's waiving. What does it mean knowingly? You have to make sure that he knows what he's waiving, etc. However, federal courts have held defendants can forfeit that right based on their conduct during the proceedings. Unlike waiver, which requires a knowing and intentional relinquishment of a known right, forfeiture results in the loss of a right regardless of the defendant's knowledge thereof and irrespective of whether the defendant intended to relinquish that right. So this has nothing to do with knowledge. This has nothing to do with intention. This has nothing to do with being voluntarily made. It has nothing to do with that. This has to do with, does your actions mean that you just forfeited your right to an attorney? Citing, again, United States versus McLeod, despite expressing concern that the defendant was not warned that his misbehavior could result in the loss of court-appointed counsel, the court nevertheless held that under certain circumstances, a defendant who is abusive toward his attorney may forfeit his right to counsel, even without warning. So do you have to give a warning? Well, United States versus McLeod says, no, you don't actually always have to give a warning to the person that, look, this is your last chance at counsel. Now, the judge did do that in this case, but still, it's not even required. The right to counsel is a shield, not a sword. A defendant has no right to manipulate his right for the purpose of delaying and disrupting the trial. At least one Florida court has also held a criminal defendant's conduct may be severe enough to warrant forfeiture of his right to court-appointed counsel. In Jackson v. State, the Third District affirmed a defendant's conviction for aggravated battery based in part on his forfeiture of his right to court-appointed counsel. The court noted the forfeiture was a result of his recalcitrance, antagonism, and even personal attacks upon each of the lengthy series of court-appointed attorneys, all of whom were required to withdraw. That sounds very similar to what happened here. There's antagonism, recalcitrance, and even personal attacks. Well, there's definitely personal attacks in this case, right? So now we have very similar. And then all these court-appointed attorneys were required to withdraw, which rendered it obvious that he simply would not permit himself to be represented by anyone. So that's exactly what happened. This is a Florida case, and this is a Florida. They're citing it as a Florida court, Jackson versus State. Because forfeiture is an extreme measure only justified by a defendant's serious misconduct, upon a declaration of forfeiture, a trial court is not obligated to conduct a Feretta hearing. So you don't have to conduct this hearing for the defendant to understand what they're doing, because it's an extreme measure which is only justified by your misconduct, or to otherwise warn a litigant of the dangers of proceeding pro se. You don't have to warn them that this is happening. Since the mid-1990s, state and federal courts have found that a defendant may forfeit his right to counsel such that the procedural safeguards typically associated with waiver of counsel do not apply. Okay, so that is what happened in KR versus Department of Children and Families. Now, I really wonder, do you think that there's ever a case where you have a similar situation where somebody was represented by an attorney and then that attorney had to withdraw and then again withdraw and then again withdraw? Exactly what happened with Sarah Boone. I wonder if you can find a case that's very similar to that, what happened in that case, and whether the judge in that case found that the defendant forfeited their right to an attorney and was actually upheld by the Supreme Court. I wonder if there's a case like that. Well, there is a case like that, and that's a case that also was cited in the judge's order. Well, this is the case right here. Watson versus State. And this was cited by the judge. And here we go. Listen to this. After the withdrawal of 6 different court-appointed attorneys, the trial court determined that Watson had forfeited his right to counsel and then proceeded to trial with Watson representing himself. Following the jury's verdict, the trial court immediately sentenced Watson. We conclude that the trial court did not err by determining that Watson had forfeited his right to counsel. However, it does not necessarily follow that he forfeited his right to have counsel for the sentencing phase, which is a critical stage. So in that case, there was a withdrawal of 6 different appointed counsel. So here it was even more than that, more than 6, at least 7. And the trial court determined in this case, in Watson versus State, that he forfeited his right to counsel. Well, certainly you can argue that in this case also, when there was a withdrawal of at least 6, more than 6, then also Sarah Boone forfeited her right to counsel. The only issue with this case, Watson versus State, is that the judge made a mistake that he did not appoint counsel for the sentencing phase. It's really 2 separate phases, right? There's the trial phase and the sentencing phase, and the judge didn't appoint him counsel for the sentencing phase and just the sentencing phase. So that was the only issue in this case. But this was upheld. This part of it, of the decision, this part of the judge finding that with the withdrawal of 6 different court-appointed attorneys, that this determination that they forfeited the right to counsel, that was upheld. So that is exactly similar to this case. So all things being said, and after we've looked at the different cases, and we've looked at the cases that James Owen cited, which have nothing to do with forfeiture of counsel, it is absolutely there's nothing to do with forfeiture. Those cases have nothing to do with withdrawing, with attorneys that are withdrawing. So you failed to cite any sort of case law that helps your position. And you, like we always talk on this channel, if you want the judge to do something, you've got to cite some authority. So find some case out there that you can start distinguishing and start saying, oh, well, maybe in that case that was worse because there was actual physical threats. Okay, at least you're starting the analysis properly. You can start distinguishing, oh, some of those cases, the defendant acted worse than Sarah Boone. So then that's an argument that lawyers make. You want to distinguish those cases and say, in this case, it would not rise to a forfeiture of her court-appointed attorneys, or of that right to have an appointed attorney. So because that was not done, there's a very, very slim chance of ever this motion being granted, as definitely as it relates to the first count. This first argument that James Owens is making on behalf of Sarah Boone. So I'm happy that we actually were able to go through this exercise and look at the cases and see how off the argument is when it comes to Sarah Boone getting a new trial based on her not really waiving her right to an attorney. And as we explained, in the beginning of that analysis is wrong because it's not a waiver. This is not a situation when there's waiver. This is a situation of forfeiture. And it's a very important distinction. So that's really what it comes down to. So I'm glad we went through this. That's going to be it for now in terms of the first argument. Maybe I'll look into some of the other case law when it comes to the other argument, but you can see kind of where we're going. Usually your first argument is your strongest. Well, we can definitely do some more research into that motion and see why maybe perhaps there is some sort of merit to any of the arguments that they make to retry this case. But definitely that first argument is completely out the window. So that's going to be it for now. Please, if you haven't yet, subscribe, like, and we will see you next time.